SwayamPrabha. Digital India. Educated India.
Hello, this is lecture number 15 and we will be dealing with the rule of law. What is this concept? What is the relevance of rule of law and how is it applicable into our country? These are the things which we will try to understand in this lecture. So, first of all we will understand about the concept of rule of law. What is the relevance of this concept, and in a legal system what weight does it carry? So, first of all we must tell you that if a legal system is only a system, then it will not be shining in the whole world. But if the legal system is also having some principles, certain values, then that system will obviously be shining like a lodestar in the whole universe. Now, one of the principles and values of our legal system is that our legal system is based upon the principle of rule of law. Now, this is what kind of concept? You will be wondering that what is this principle all about? Now, this principle is all about, you might have heard the maxim that law rules. Why does law rule? Why not men rule? Why not a particular group of people rule? Why not there should be a rule of prime minister? Why should there be a rule of law? Why should there not be a rule of the president? Why should not be there a rule of one person in the whole family? This is what we say that the rule of law is about. We must try to understand why this rule of law is relevant. So, in considering these things, we will tell you that rule of law, first of all, simple meaning is that where the law rules, not one person rules, not a group of persons rule, not prime minister rules, even a person is so powerful, but more powerful than that person will be law. That is called the rule of law. Be you ever so high, law will be above you. This is the concept of rule of law. It means that you rise to any height, you go to acquire any position of power, but that powerful person must also abide by the law. This is called the rule of law. So, the rule of law is a concept which is derived from the French phrase la principle de legalite. It means that the principle of legality and the government should be based upon the principle of law and not of the men or the women. So, this is the concept which is having this root in these different systems. We will also talk about the British system, how the rule of law concept was developed in the British system and also in the French system and also in our own legal system. Our own legal system had also talked about the rule of law, where dharma rules. Dharma means the law, dharma means the right law, and where the dharma ruled, be you so high, even if you become the king, but the law will be ruling over you, the dharma will rule over you, and if the king will not abide by the dharma, then the king will be overthrown or king's kingdom will be lost. It was said in the ancient times in our country that dharma chhatrasya chhatra, means that the dharma is the king of the kings. Chhatra means king and dharma chhatrasya chhatra means the king of kings. So, who is above the king? Who is above the powerful and mighty? The rule of law is above any powerful person. And therefore, if this is the principle, if this principle is enshrined in a legal system, that means that the legal system has lot of shine, lot of good qualities, and that legal system will definitely be differentiating from the other legal systems of the whole world. So, why you will consider, why is it not that people, so many people elect a prime minister, and then why not prime minister should have a rule over the country? Why there is a need of rule of law? The answer is that maybe that prime minister people have elected, but prime ministers are given some tenure and they are very powerful, lot of powers are enjoyed by the prime minister. So, in that case, suppose if the prime minister is using or sometimes misusing the discretion or the power which has been vested in him or her, in that case what will happen? There will not be the rule of law, rather that will be the rule of the prime minister. If the prime minister will be doing everything according to the right thing, right conduct, right behavior, then it is very good, but otherwise there should be some predetermined rules, and even the king or the most powerful, they should abide by those rules, those standard of conduct. Only then the prime minister's office will shine. So, what I was saying, that the rule of law is a very important principle which is of value, and our legal system has also enshrined this philosophy, this principle, and other legal systems of the whole world. I gave you the example of France, that how law, the maxim law principle de legalite, that was there, and in Britain also we will see that there was a Lord Justice Edward Coke. So, he also originated in Britain the principle of rule of law. It can't be said that Coke was the originator of rule of law in all over the world, but yes, Lord Justice Coke was there. He was also in Britain. He had in different judgments, he had also tried to tell and promote the concept of rule of law. And why was there this fact that rule of law was given more encouragement by the judges also? Because at that time also you might have heard that how powerful was the kings in those times. So, how to protect the individuals, how to protect the citizens from the powers of the king. So, to do that, to achieve this thing, that the individuals must be protected, therefore, what happened, that arbitrary authority, there should not be any arbitrary authority of the government, and the rule of law, if there would be rule of law, it will protect the individuals from unlawful action of the government, and therefore, the rule of law, this concept was promoted. So, then we will move on to the other philosopher of Britain, and his work has been also considered to be phenomenal in the development of the rule of law concept in the modern times. Dicey, A.V. Dicey, Professor A.V. Dicey, who was a professor of law in UK, he had written the book Law of the Constitution in the last part of the 19th century, and his book became very famous, classic book, because he had in that book promoted the concept of rule of law, but he said that there will be main three important components of rule of law that we should also try to understand. And those three things of the rule of law were, first, that there should be supremacy of law. Law will rule, not the person, not an individual. The law will rule, that will be called rule of law. And the second thing will be that there will be equality before law. I must tell you that in the centuries before the late 19th century, and even in 19th century, and also in the 20th century, half of the 20th century at least, that there was inequality spread all over the world. People who were not rich, they were not given due care. People who were not having fair skin, white skin, they were not treated well. People who had black skin, they were treated differently, very differently. Many people were slaves, many people were bonded laborers, many people were suffering from any kind of right to vote. So, you see that this was the world, unequal world. People were trying to have equality. Humanity was suffering. So, at that moment of time, when Dicey said that rule of law means there should be equality before law, then that gave a huge promotion to the concept of rule of law, because if there will be no rule of law without this equality amongst the people, then what will happen, that the value of law, the weight of law, that will erode over the time, because the law promotes inequality. So, to have equality, to have rule of law, there should be equality amongst the people, there must be equality in the eyes of law. Before the law, there should not be distinction, because you see that when I told you about French legal system and the principle of la principe de legalite, I told you that in France there was a system where there was different tribunals for different kinds of people. People who were a job in the administration, the French government, they had a different tribunal for them, and the peasants, the laborers, they had different tribunals, they had different institutions to resolve their disputes. So, there was not equality. People were thinking that we are different, we are not equal with others. The king is very powerful, on the other hand merchants were very powerful, the traders were very powerful, but the laborers, the peasants, the farmers, they were not powerful, they were not having the same rights. So, when rule of law in the new color that came in the times of Professor A.V. Dicey, he said that to have rule of law, we must have equality before law. So, it is equality concept that gave a lot of impetus in the promotion of the rule of law. And then the third was that there should be less exercise of discretionary powers. In fact, he said that there should be no abuse of discretionary powers, and he said there should be absence of discretionary powers. So, why did he say so? Because at that time I told you that there was the concept was also a kind of development as a reaction to the powers of the king. So, this was the fact that people were trying to have a code of conduct for the king also, and therefore, what they thought, that when the king could be exercising his powers without any kind of restraint on his powers, that decision may be arbitrary. Or likewise, if he delegates his powers to some of his ministers, or if he delegates the powers even to the judges of the court, that also can be the cause that these people, they can exercise discretionary powers, and discretion may be fine, but abuse of discretion, if there is a misuse of discretionary powers, then Dicey was saying that this will not promote rule of law, because if you have the rule of law, then there should be less and less discretionary powers, and if there is a discretionary power, it should not be misused, it should not be abused. So, these were some of the things of the Dicey's concept of rule of law, and therefore, because if we talk of the rule of law in our country during the ancient times, we can say that it was there that dharmasya chhatra, dharma chhatrasya chhatra, meant that dharma was the ruler of the rulers. But when it came to the inequality, because at that time also you must have a sense that in those times inequality was maintained. There was no provision by which it was said that everyone is equal. So, that equality gave lot of important boost, and likewise if you go to the ancient texts, you will find that it was also said that king had a lot of discretion, although at the same time they said that no, king should also abide by the law, but at the same time they also said that king can have discretionary powers. But here our Dharma Shastras, they dealt with differently. They said that no, king should also be bound by the laws, the good conduct, and therefore they should not be arbitrary while exercising their powers. So that was the thing, but then equality, on the equality count, perhaps Dicey's rule of law, that became more popular and more powerful in the modern times. Now, as far as the supremacy of law is concerned, that is also, it is very easy to understand that law must be considered as the supreme. Now, that has to be imbibed in the minds of the people. It is not that just in the text, if it is written that law is supreme, that will not be sufficient, because in the ancient times also it was said that if a ruler protects the dharma, then only dharma will protect the weak. So why the power of the king is needed with the power of the dharma? Because of the fact that if dharma and the powerful, both these persons will combine together, then the weak can be protected, the people who are helpless, the people who are old, the people who are having less money or they are poor, they can be protected from the whims and fancies of the traders or the different communities. And therefore, in those times also this was the system, and in the modern times, supremacy of law, this concept means that law should be given supremacy, law should be considered to be supreme even by all the powerful people of the country or of the legal system. So who are the powerful persons as far as the legal system is concerned? The judges. The judges are very powerful, and the judges, therefore, they should also be having this duty that they should consider law as the supreme, the codified laws, and the judges do it. So when we go on to look at the another component of rule of law given by Dicey, he said again equality before law, and I have already told you about this importance of this system. And the last thing what Dicey said was predominance of legal spirit, and ultimately that gave rise to the fact that how constitution is the product of the legal spirit which is found in the different laws. But then this concept is not applicable right now, because we now consider that if there is a country where constitution has been there, so constitution will be the originator of all the different laws, or so we will not accept this fourth component of Dicey, where he said that predominance of legal spirit, and ultimately the constitution is the product of the legal spirit which is found in the different laws. So this is not that much applicable to those countries where there is a constitution. As far as Dicey's concept of rule of law was there, he was very good in examining the then context of that time, and he had examined the French system of droit administratif, where for the people who are there in the administration, they had to go to different courts. So that was there, but Dicey said that that system was designed to protect the officials, and but Dicey was not right, because he could not understand that this was not the case. And then Dicey also did not refer to the prerogative writs of mandamus, prohibition and certiorari, by which the superior courts could exercise control over the administrative action and adjudication. So these are some of the criticisms of the rule of law which was given by Dicey, but I told you that Dicey was one of the several professors or several saints and sages or the policy makers who had promoted the rule of law in the different parts of the whole world. But as far as the rule of law is applicable in our own country, we will say that we have a long tradition, as I told you earlier, that the tradition has been that dharma shastras, vyavhar shastras and niti shastras, we have a long tradition. It is not that only one or two authors, but you see that the earliest example of having this kind of rule of law will be the code of Manu, which was written thousands of years back. And then you see that there are several others like Yagvalkya Smriti, like Kautilya's Arthashastras. So you see that in all these texts you will be astonished to know that rule of law, the concept of rule of law was very much given high pedestal in all these texts. But as far as the modern times is concerned, we must understand that the whole ideal of rule of law or the whole principle of rule of law has been accepted in our country since the time when the Constitution of India was adopted, because Constitution is the highest law of the land. And in our country, if the Constitution has not incorporated the rule of law, it means that our legal system has not incorporated the rule of law. So, we will have to see that whether our Constitution has also incorporated the concept of rule of law. The answer is yes. And how it is yes, we will see by examining some of the provisions of the Constitution, and then we will see that in some judgments also how this rule of law concept has been also favored by the judiciary. So, we will look at some of the provisions of the Constitution. Now, look at the first of all, before looking at those provisions, I will first of all tell you that every powerful person of the country, they must always abide by the Constitution. If that is not the case, then the rule of law, even if it is enshrined in the Constitution, that will not be finding favor and that will not be finding ultimate effectiveness in the whole country. So, if it is the fact that the highest or the most powerful person of the country is also abiding by the Constitution, it means that Constitution, if it is enshrining the rule of law, then the most powerful person will also abide by the rule of law. Now, look at the fact whether our Prime Minister of our country takes the oath of his office by touching or by looking at which text. Again, the answer is Constitution. When the Prime Minister assumes his office, he takes oath on the Constitution. He says that I will give due respect and the provisions of the Constitution will be respected by me while I will be there. Now, Prime Minister, who is the most powerful person of the country, the President of India, who is the most powerful country, President of India, when he or she takes the oath of his office, what does he take oath upon? He or she takes oath upon the Constitution of our country. So, you see that these are some of the examples. The Chief Justice of India, he is also the most powerful person of the country. Now, whom does he report? He does not report to anyone but the Constitution. He takes oath on the Constitution. He takes oath that he will abide by the provisions and the ideals of the Constitution. So, these are some of the examples that the rule of law, if it is enshrined in the Constitution, then whether the high and powerful people of our country, they also take oath upon them? The answer is yes. Then we must look at the provisions of our Constitution. What are those provisions of our Constitution which deal with these aspects of the rule of law? Means, what were those rules? Like whether there is supremacy of law, whether there is a equality before law, whether there is a less arbitrary powers in the hands of the people who are having lot of powers, and we will also see that what is the nature of our constitution. So, first of all we will see that whether there is a supremacy of law or not. As far as the constitution is concerned, you must be knowing that in various judgments of the Supreme Court, it has been laid down that the constitution is the highest document of this country, is the highest law of the country, and the Supreme Court will not try to change any provision in the constitution, because this is not in the domain of the Supreme Court. Supreme Court can just interpret, can give a new dimension, can give a new meaning to the existing word, but it cannot change the whole meaning of the word. It cannot destroy a particular provision. So, there is a supremacy of law. The Prime Minister also abides by the law which is there, and if he or she will not abide by the law, then there is a possibility that kind of action under the law, given law, can be taken. Chief Ministers are also not above law, and Chief Ministers, if they will not perform their duties which are there under the law, then they will also face the music of law. So, these are some of the examples of supremacy of law. And the second is that equality before law. How our constitution have maintained equality before law. You will find that there is a fundamental rights chapter in our constitution, and the part 3rd of our constitution, which talks about the fundamental rights in the early provisions only, articles 14, 15, 16, 17, 18, all these articles deal with equality provisions. So, and then move on to the other provisions also, but these are the main articles of the constitution which talk about equality before law, where it is said that there will be equality before law and equal protection of laws. So, we see that this is also enshrined, the equality before law concept has been also enshrined in the constitution, and therefore, it promotes the rule of law in our country. Then we will see that the third, what is the possibility of reduction of the arbitrary powers of the king. You will find that the writs can be issued against the government. Now, who can issue the writ? Then suppose if there is an arbitrary exercise of power, then there is a possibility under article 32 and 226 of the constitution that different writs can be issued by the higher courts, like the high courts and the Supreme Court, and these writs can be habeas corpus writ, mandamus, certiorari, quo warranto, prohibition. Now, these all writs are there with a aim that the discretion should not be misused, and also the courts enjoy the power, the higher courts, they enjoy the power of judicial review. Suppose if a legislature becomes so powerful that they make a law which may be challenged by many other persons. Now, in that case the courts can review that law, whether the law passed by the legislature is according to the constitution or not, which has enshrined the rule of law. So, this is also important, and at many junctures the Supreme Court has examined the law passed by the union legislature and found ultra vires the constitutional provisions. So, you see that ultimately the standard on which a law is examined, that standard is the constitution. So, in our country we have seen that in our country a lot of provisions are there by which the rule of law as enshrined in the Dharma Shastras, as enshrined in the different other legal systems, and those are incorporated in our legal system also. Then we talk about Article 21. 21 is about the freedom of speech. Article 21 is about right to life and personal liberty. So, that is also very important right of any individual, and here is also that how a king can, suppose a king can exercise his arbitrary powers against the individual taking right to life, then that will not be acceptable and a writ can be issued in such a case. We will also look at some of the landmark cases, but before going on to the cases, I must tell you that if the judges are powerful, then we must also know that whether these judges, why they are made powerful, because they are made powerful to protect the constitution. They are not made powerful to abuse their position, and if they are doing that, then there should be also a possibility that the executive will try to say something to the judiciary, and suppose for example, a law is made, then whether the judiciary has the power to say something on it, and suppose if the judiciary says something on it, like if the law has been passed by the parliament and then suppose judiciary has the courage to say no or quashes the law. Now, in that case, can that judge be removed? Whether what is the security of the tenure of the judge, whether the judge of the Supreme Court or whether the judge of the High Court, whether they have any kind of fear from the executive, because then it will be difficult for them to protect the constitution. Now, as far as our constitution is concerned, we have also the provision like article 124, which says that the appointment of the judge of the Supreme Court that will be free from any kind of political pressure, and 124 coupled with the judgment of the Supreme Court in S.P. Gupta versus Union of India. From then you see the collegium system, etc. So, after that, now the position is that the appointment of judges of the Supreme Court and the High Court, that is not in the hands of the executive. So, we will also talk about all these things in the separation of powers concept, but right now what I will tell you that this is also very important, that how judiciary should be made independent, because if it is not independent, if it is dependent upon executive, then the constitution cannot be protected and then the rule of law will not be ensured. So, to have rule of law in our country, to have protection of the constitution in our country, it is very important that the judges, the appointment of judges, they should be free from any political or executive interference. So, having said about some of these provisions, we must also try to understand that suppose if a political party which has the control over the legislature and it has also made the head of the country like executive head, for example, that party has the prime minister also, because in our legal system and political system, the situation is that the political party who has the prime minister, that political party has control over the legislature also. In some cases, there has been instances where a political party has absolute majority in both the houses of the parliament, and at several instances it has been found that the or it is the fact that the political party which enjoys power, who is in the executive, they can have control over at least one house of the union legislature. So, in that case, if that is there, then can there be a possibility that the executive can amend the constitution? And suppose if the constitution can be amended, then can there be supremacy of the rule of law? Now, here we have to understand that there is a procedure which is given in the constitution, and therefore, if that procedure will not be followed, then no political party, even that political party be so powerful, that political party cannot change the constitution. But the question remains that suppose if a political party abides by the procedure which is mentioned in the constitution, then can the whole fabric of the constitution be changed? The answer is no, because we will not look at the fact that how the political party has looked at it. We will have to see that the amendment, what can be the extent of amendment. Suppose if the amendment is about the fundamental rights, suppose if the amendment is about the directive principles of state policy, now whether that can be allowed, and if that is allowed, whether this will be the promotion of rule of law. So, these are some of the questions that also we must try to understand. Suppose if a political party wants to change the democratic system and replace it with a kind of authoritarian system, whether this will be promoting the rule of law. Now, to understand all these questions, we have also to look at the different judgments of the courts. Let us try to understand some of the judgments of the different courts of our country, so that we will have a look at the rule of law in a better way. First of all, we will look at one case, State of MP versus Thakur Bharat Singh, that was of the year 1967, and in this case it was held that we have adopted not the continental system, but the British system. So, this was how the judgment held, and then it held that our federal structure is founded on fundamental principles like the rule of law. So, this was one of the earliest judgments in which it was said that our system, our rule of law, our constitution is based upon the rule of law. So, in that case, in the state of MP, the Supreme Court laid down the principle that in our country also we have the rule of law and our government is based upon the rule of law. Then we will also look at some other judgments. First of all, we will look at one of the examples, which was the example of the time of emergency. You might have heard about emergency. In emergency, you may be used to now every time surfing the internet, you may be used to going to the market or shopping complexes or the malls anytime. You may want to go to a movie hall, and you may also want to go to any location in our country and abroad. Now, this is all about your liberty, and suppose I told you that Article 21 protects the right to life and personal liberty, and Article 19 deals with the freedom of speech and expression, and also to travel. So, you see that these are some of the fundamental rights which are there for the individuals of our country. Now, what happened that in our country emergency was imposed, and you know what, when emergency is imposed, national emergency is imposed, what will happen? I told you, you want to always surf your internet will be jammed, or maybe that it will be stopped working, or you want to go to some shopping complex, you will not be allowed to go. You want to say something about the government, you will not be allowed to do. You want to travel to any part of the country, you will not be allowed to do. You may also be willing to travel abroad, maybe that you will not be allowed to do. There will be several restrictions on your movement, on the way in which you want to do something. You want to study, maybe that some restrictions will be imposed even on your study. If a professor wants to give lectures, maybe that some restriction may be imposed upon the professor while giving the lectures. So, all these are the results of emergency, and you know what, emergency was imposed in our country in 1975, and in the mid year June 1975, when emergency was imposed, you might be astonished to know that many leaders of the country, they were put in jail. Why? Because they had dared to say or to criticize the government, or they would tell something negative about the government or fair comment about the government, but the government will not accept it. So, many persons, they landed up in jail. The jails of our country, they were all filled up with people who wanted to have liberty, who wanted to have some sort of freedom of movement, right to life, but those people were detained. They were detained without producing them to the local magistrate. Now, in such a situation, what will happen? Whether this will be a rule of law? When the Prime Minister and the party in power, what they did, that they used a provision of the Constitution. In Constitution of our country, at that moment of time, there was a provision that national emergency can be imposed on the ground of internal security. Now, on this ground, on the recommendation of the Prime Minister, the emergency was imposed on the whole country. Now, you see that this was what, and up till here also this maybe might have been fine, but what happened, that this was so misused that again another law came, Maintenance of Internal Security Act, which is infamously called as MISA, and you know that some leaders which are very prominent even today, they also went to jail, and then when they were in jail, then one of the leaders had a baby, and that baby girl was named as Misa, because at that moment of time he could not see his daughter when she was born. So, you see that those were kind of examples of that time, but you see one of those persons, he filed a writ petition and his name was Shivkant Shukla, and he filed a writ petition in the High Court of Jabalpur in MP. And what happened, that when this matter was going on, thousands of writ petitions, they also were filed in different high courts of our country. And you know what, that ultimately all those writ petitions were bunched together, and finally it was heard by the Supreme Court. And you know what, in the Supreme Court, the contention of Shivkant Shukla was, Lordship, the Constitution is there, and there is a provision that the Constitution can be amended, there can be presidential proclamation of emergency, and this can happen. But at the same time, Shivkant Shukla was saying that people's liberty is also supreme, and this should not be compromised. If you are detaining a person, then that person should be produced before the local magistrate, and the local magistrate will see that okay, whether his detention is fine or not. It should not be just upon the doubt or suspicion of the detaining authority. It should not be in the hands of the police that they will detain any person. It should not be like that, rather it should be based upon the fundamental human rights of the person. So, in this case what happened, that Shivkant Shukla was trying to convince the court, Supreme Court, your Lordship, it should not be like this. We have the Constitution, and the Constitution should not have been misused by imposing national emergency in this way, that the police person, the security people, they will detain any person for indefinite period of time without any possibility that when they will be released. So, when the matter went to the court, the judges, they were also amused, because the government was saying that Lordship, it has no problems, it is perfectly legal, the Constitution allows imposition of the President's rule on this ground, and therefore, the government has the power to do it, and government has used its power. There is no misuse of power, there is no abuse of power, it is simply the application of the Constitution when there was a problem of internal security. But ADM Jabalpur was there, ADM Jabalpur represented the state, and Shivkant Shukla was saying, your lordship, okay, there is the constitution, but where is the human rights? Our country has also signed Universal Declaration on Human Rights, and lordship, in the Universal Declaration on Human Rights, there is a provision that even during the times of emergency, right to life should not be taken away. So, where is our obligation? We are not following this obligation. Now, when this contention was there, majority of the judges of the Supreme Court, what they could have done, whether they would accept the contention of Shivkant Shukla or the judges would accept the contention of the government, it will be a very difficult case, because if you look at the rule of law, law rules. Which law rules? If the constitution has the rule of law, the constitution rules. So, here the contention of the government was that constitution rules. So, there should not be any problem, but you see ADM Jabalpur versus Shivkant Shukla case will give you the clue that Shivkant Shukla was saying, lordship, but fundamental human rights, this is a question of fundamental human rights and this should not be compromised. At least right to life is a very important fundamental right, this should not have been compromised, and therefore, this should not have been done even if you impose national emergency, but you cannot take away the right to life of a citizen and the personal liberty of the citizen. You know what? Finally, when the court decided this matter, ADM Jabalpur versus Shivkant Shukla, AIR 1976, Supreme Court 1206. When this case was decided by the Supreme Court finally gave the judgment in favor of the state, saying that rule of law has been maintained by the government and constitution permitted it, and therefore, there is no violation of rule of law. However, there was one judge of the court, only one judge in the whole Supreme Court, who gave a dissenting opinion. Do you know what he said? He said that I have the courage to say it differently. He said that the government is a signatory to the Universal Declaration of Human Rights, and therefore, if there is no direct conflict between the constitution and the international commitment that we did, then why should not we respect international commitment? If there would have been a conflict between the constitution and the international commitment, obviously domestic commitment, obviously the national law will prevail. But if there is no direct conflict, then also we are facing problem. Why should not we respect the human rights of the persons? Many people are in jail, and you know what? Who was that judge? Everyone remembers that judge. You might also remember, you might also have heard the name of that judge. That judge was Justice H.R. Khanna. So, Justice H.R. Khanna was like Ekla Chalode, like Rabindranath Tagore. He had given a very good song, Ekla Chalode. He had the courage to do it, he did it differently, he said it differently, and all the other judges, they had their own view about rule of law. So, this is a case where the concept of rule of law was debated, and there were problems that what is the right interpretation of rule of law. But you know what, that the Ekla Chalode, the dissenting opinion of Justice H.R. Khanna, that became the constitutional provision just in 2 years, when the new government came after the elections, after emergency, when the new government came, the constitution was amended, and after the 44th amendment, today the position is that even when emergency will be imposed in our country, although internal security ground has been also removed, but even otherwise, if the national emergency is imposed, Article 20 rights and Article 21 rights cannot be taken away. So, now even if the government, any powerful government will come, but if that government will impose emergency, then what will happen, that the emergency cannot take away Article 21 rights of the citizens and Article 20 rights of the citizens. So, this is the result, this is the powerful result of ADM Jabalpur. Likewise, we have some other cases like Menka Gandhi versus Union of India. You know, Menka Gandhi was a powerful leader, even today she is there, so she enjoys many powerful positions. But what I was telling you that, you know, there was a time when she was not powerful and she was, you know, willing to go to some foreign country because her presentation was accepted and she had to present her paper in a foreign country, and she wanted passport because she didn't have passport. Because you want to go abroad, you must have passport. She applied for the passport, and you know what, her passport was impounded by the passport authority. Why was it impounded? Because there was a provision in the Passport Act of 1967 that if the passport officials find that the passport should not be issued, then they can not issue the passport, or if the passport has been there, it can be impounded. So what happened? Menka Gandhi could not travel abroad when she was invited to travel abroad, because the government of the country feared that when she will go abroad, then she will criticize the government. And because she was very close to the Prime Minister, she was the Bahu of Prime Minister, and therefore the Prime Minister was thinking that what will happen if she will go abroad and she will criticize me or me and my government. So what happened that Menka Gandhi passport was impounded, but Menka Gandhi did not rest there. Menka Gandhi went to the court, and Menka Gandhi contended in the court, Lordship, what is this happening? Passport authority, they are impounding my passport without even hearing me. They did not hear me, they did not invite me to say something why my passport is going to be impounded. They did not ask me, and simply because they had the power, they misused their power. This is a sheer abuse of power, and there is no rule of law in our country. There should have been rule of law. Then the Union of India was saying, Lordship, the Passport Act has section 10, and then this section authorizes the passport officials to impound the passport of any individual of our country, and this power is perfectly legal because this has been given in the law. So there is a rule of law. But Menka Gandhi was saying differently. Menka Gandhi said, Lordship, it should not be there, because rule of law does not mean rule of any law, but rule of a reasonable law, rule of a fair law. So fairness in law, reasonableness in law, that should also be ensured. It should not be any kind of rule of law. Rule of law means that there should be a rule of fair law, rule of reasonable law, and that was very important, and the court agreed with the contention of Menka Gandhi, and court gave the verdict that this should not have been done. You must have heard her first. Without impounding or before impounding the passport of Menka Gandhi, you must have heard her, and only thereafter you should have impounded the passport. This is a very important principle of justice, and the court said that the principle of hearing to the affected person, that is the cardinal principle of rule of law, which was not there, which was not present in this case. So Menka Gandhi's case is also very important, and therefore we must have seen that how in our country, these are some of the examples, there are many examples I could not give you, but there are so many examples on rule of law. I hope that you must have understood the whole concept of rule of law, how this is being applied in our country, and how the Constitution has enshrined the rule of law in our whole legal system. And even when the Constitution was adopted in the last 75-76 years, how our judiciary and other powerful persons, they have also tried to accept the whole rule of law concept given in the Constitution and in our country. So I hope that you must have understood this concept. Thank you so much.
Hello everybody. Now the discussion which I would try to make talk to you is about the excitement which I always feel, and I am sure you will also reciprocate as I proceed and when you do the course, is in the area of multivariate statistical problems and multivariate statistical analysis. So, what we mean by multivariate? So, we know that statistics is a subject where you have a lot of data, you try to analyze that using different type of techniques like estimation problem, MCMC techniques, then forecasting and the area of time series analysis, and then try to basically find out the best forecasting tool which you have, such that you are able to gain the maximum amount of information from a set of data. Now, in the recent past, as we see that multivariate statistics has really increased in a very exciting manner, and if I trace back to history, it has been going on slowly for the last about 70-80 years, but now the time has come where it is being used in a very big way, and the techniques which we all know, but which are being utilized with new vigor are in the area of, say for example, canonical correlation technique, in the area of factor analysis, in the area of conjoint analysis, in the area of clustering analysis, in the area of multi-dimensional scaling techniques, structural equation modeling, be it in the area of finance, be it in the area of engineering, be it in the area of social sciences, be it in the area of economics, such that you are able to gather the information from the data in such a way that it really gives you some useful set of information. Now, in the recent past, there has been also an explosion of large and complex data sets, but added to that there has also been a commensurate increase in the computing and the statistical techniques. So, obviously, the question comes that if the statistical techniques are there for so called small data, not the big data, not the data which is of terabytes and so on and so forth, where you use different type of computers to store the data, the question obviously comes that are those statistical techniques really relevant when we use them in the big data sense. The question is, they are not always relevant, they may not give you the best results. So, what we are seeing in years to come, and I feel very excited about that, is that how the new tools which we have already learned in statistics, in multivariate statistical analysis, are being redrawn, are being, say for example, remodeled in such a way that they can be utilized along with the techniques of computing in a very nice manner, that we are able to garner the information from big data very successfully and very nicely in such a way that they are able to portray a sense of information which we all long to have from big data, be it in, say for example, medical sciences, be in the area of finance, be it in weather forecasting, be it in transportation, so on and so forth. So, obviously, it means that students, participants who are in a position with some brief mathematical background to take multivariate statistics and statistical tools as a subject in this program are assured of a very exciting future, where they can use these tools to both gain the knowledge as well utilize them in a very best practical sense, such that they are able to do some justice to the information which is given to them and get the best information from the data sets. I wish all the participants in this course the best of luck, and I am sure they will also reciprocate the excitement which I have for this type of courses. Thank you.